Okay, so we left off and we are moving into part two, a continued reading of the Kuether versus Posley MPS board, Milwaukee Public Schools, and as read in part one, a variety of individuals in both their official and individual capacities. We left off on number 4, and I will pick up from there now. In early 2022, the media gave Kuether's public criticism of MPS significant publicity. In response, MPS doubled down on retaliation. On January 18th, 2022, Channel 4 News, TMJ Milwaukee, ran a story about the dispute. Sean Gallagher, quotes, says, state agency finds probable cause against Milwaukee Public Schools violated hiring laws based on retaliation complaint, end quote. That story mentioned Holliday's ERD complaint. Lastly, the I-team found Holliday filed his own ERD complaint against the district, naming Posley. Then the link is provided here. On March 7th, 2022, Channel 4 News, TMJ Milwaukee, ran another story about the dispute. Sean Gallagher, I-team, MPS, quote, work conditions are the worst they have ever been. Report on retaliation shows. And you can link that right here in this news article if you choose to look at that. On June 7th, 2022, Channel 12 News, WISN Milwaukee, ran a story about the dispute. Jerron Jordan, quote, his story was Group Wants Milwaukee Public Schools Superintendent Fired, end quote. The story featured images of Kuether and others carrying signs and demanding Posley's resignation. There's the link for that story as well. On September 20th, 2022, Channel 4 News ran another story about the dispute. Sean Gallagher, quote, whistleblower accuses MPS of intentionally harming advancement of minority students. The link is there for that story as well. Media featured Kuether in many other articles and some gaining statewide and national attention. In response, MPS blacklisted Kuether. Upon information and belief, Saffold sabotaged Kuether's ability to find other employment by failing to return emails and phone calls to acknowledge Kuether's employment when prospective employers called. In November of 2022, days before a hearing on whether MPS discriminated against Dr. Jose Garcia Joven, MPS refused to honor notices for Posley and Holliday despite a previous agreement to attend. Low on resources, Garcia Joven asked Kuether to serve Holliday and Posley for his hearing as the last resort for the last-minute refusal by MPS. On November 8th, 2022, Kuether served Holliday for Garcia Joven's ERD hearing. After opening the door, Holliday said, "Oh no, not you," and slammed the door, pinned Kuether between the door and the doorframe, and pushed his entire weight until Kuether wiggled free. Holliday caused physical and emotional injuries to Kuether. Milwaukee Police Department, MPD, investigated and cited Holliday for assault and battery. His trial is scheduled for June 18th, 2024. Number 5, defendants curtail Kuether's protected speech in designated public forums. During spring of 2023, Kuether appeared at board meetings, which she encouraged others, including media, to attend. She attended these meetings carrying protest signs in accordance with policy, sat next to the parents and MPS employees, and provided democratic criticism before the board. See also Group Wants Milwaukee Public Schools Superintendent Fired above. In response, the board changed official rules, policies, and customs related to board meetings, or set them aside entirely to target and restrict Kuether from exercising public speech. Defendants admonished Kuether for holding a sign that complied with all applicable rules of decorum, increased security detail at board meetings, and ordered security detail to give a special sign upon confirming Kuether's attendance, to enact special security protocols, and use additional resources to stifle Kuether. The board, Posley and Mann, also packed meetings with senior administration to keep tabs on, to intimidate Kuether and others from expressing contrary viewpoints and political affiliations at those meetings, and to convey public support for the MPS administration. During a May 21st, 2023 board meeting, Peterson, while president, shut down discussion, including Kuether's public testimony, went into recess and closed session for the purpose of blocking discussion because Kuether exercised her free speech rights in a public forum. Peterson stated that Kuether had disrupted the board's orderly process. Kuether's conduct was not disorderly. By contrast, other members of the public who were present at the meeting were allowed to use curse words during their time to speak. Peterson, Herndon, and other board members singled Kuether out, giving other speakers 2 minutes and 15 seconds to present their viewpoints. On March 17, 2022, Kuether registered per MPS policy to provide virtual testimony at the board meeting. Upon information and belief to prevent Kuether from providing testimony, defendants, MPS, and board intentionally failed to provide Kuether with the access link until after the meeting concluded, depriving her of the right to provide comment at the forum. On May 5th, 2022, Kuether registered per MPS policy to provide virtual testimony at a board meeting. Defendants Gokul Gandhi and Mann turned off Kuether's microphone 45 seconds into the allotted 2 minute and 15 seconds time allotment, preventing a speaker they harbored animus toward from making further speech solely because they found it disagreeable. In doing so, defendants interfered with and violated Kuether's right to make speech at a public forum. While Gokul Gandhi and Mann claimed that Kuether was, quote, off topic, she discussed proficiency rates and budget and generally echoed the same sentiment that the two previous speakers did in their testimony. The previous speakers were not cut off. After Gokul Gandhi and Mann removed Kuether from the meeting, she resorted to submitting her written statement via email to the board. On July 28, 2022, Kuether registered to speak virtually at the board meeting to discuss the superintendent's recommendation to place former Chief Marla Brunau into a newly created Director of Remote Work position. Kuether attended the board meeting virtually because meetings were not yet in person. Peterson and Mann allowed a speaker to speak who, quote, pledged to support the new principal. Mann started the timer early for Kuether. After Kuether said, "This is yet another example of the superintendent abusing his power and providing a different standard of treatment for a particular person," Mann and Peterson discussed cutting Kuether's testimony and then did so. See at the 2 hour, 30 minute, and 20-second mark in this YouTube video. You can see that actually occur. On March 28, 2023, Kuether and other members of the public invited the press to attend the Public Board of School Directors meeting. Kuether gave public testimony. To prevent Kuether and others from speaking, especially with the media present, the directors abruptly moved their meeting into closed session and removed the public from the auditorium. On June 22nd, 2023, Kuether waited 2.5 hours for the chance to be the only person giving 2 minutes and 15 seconds of oral testimony to the school board on the MPS budget. During her testimony, Board Director O'Halloran told her she was off topic, spoke over Kuether, telling her that her time has expired, despite her timer still showing speaking time remaining. The board turned off Kuether's microphone. On October 19, 2023, Kuether registered to provide testimony in accordance with policy. Kuether was speaking in support of the anti-bullying policy and referenced violence in MPS Central Services against female employees. Another female employee, Angela Harris, testified about an attack she experienced from a parent and was not cut off. President Herndon interrupted and spoke over Kuether's testimony and eventually turned off Kuether's mic prior to the expiration of her allotted time. If you go to this link and you go to 16 minutes and 53 seconds, you can see that happen. On December 19th, 2023, an MPS employee contacted Kuether through her personal social media in response to Kuether's comment on the official MPS Facebook page, quote, "Children need to be the priority and not high-paid administrators. The mission of public education should be the focus," end quote. On information and belief under the direction from Posley, the MPS employee messaged Kuether that no other political statement should be made on MPS Facebook posts, or Kuether would face legal ramifications. In August 2023, MPS terminated Kuether's employment while she was on leave. Kuether's termination was not customary or in accordance with precedents or practice and violated Kuether's due process. MPS never processed Kuether's wrongful termination grievance. On October 24th, 2023, Kuether was the lone speaker and waited for 90 minutes to speak for her allotted 2 minutes and 15 seconds. The board received and acknowledged Kuether's speaker slip. During the testimony portion, Mann ignored Kuether and forced Kuether to interrupt the board to ask if she could speak in accordance with policy. Carr promoted a January 15th, 2024 Facebook Live public meeting in which she discussed matters of public concern in her role as school board director. Although Carr promoted the event as open to the public, Carr hosted the event using her personal Facebook profile and refused entry to Kuether. Carr told third parties that if Kuether is present at community events, she will cancel the event. Kuether did not attend a March 23, 2024 public event co-hosted by Carr because of Carr's statements. Upon information and belief, Posley, Furman, Holliday, Mann, Peterson, Herndon, O'Halloran, Gokul Gandhi, Carr, and Herndon told employees, parents, and members of the public not to associate with Kuether. Employees, parents, and members of the public told Kuether that they are afraid to associate with her because of retaliation from Posley, Furman, Holliday, Mann, Peterson, O'Halloran, Gokul Gandhi, Carr, and Herndon. Part 6. Board directors and Posleys, acting as custodians of public records, retaliate against Kuether. Wisconsin law entrusts public records to custodians, and elected political officials are custodians of those public records. Kuether requested public records from the board through Mann, from the district through Chasen, and from individual board directors directly to the directors, including Peterson, Herndon, O'Halloran, Gokul Gandhi, Carr, and Herndon. For example, in March 2022, Kuether made an open records request for settlements associated with MPS and the board. MPS took 17 months to respond to the request and withheld documents, such as the bowling settlement. Another open records request made in March 2022 by Kuether to MPS and the board was regarding expenditure on legal services. MPS and the board did not respond to the request until September 29th, 2023, some 18 months after the original request. MPS response was significantly delayed and only partially fulfilled. Mann, Posley, and individual board directors, including Peterson, Herndon, O'Halloran, Gokul Gandhi, Carr, refused to produce or unreasonably delayed the production of public records in response to Kuether's requests. Claims for relief. Count 1. Discrimination based on political association in violation of the First Amendment, Chapter 42, 1983. I won't read all those specifics, but maybe I will. I'll start here with the First Amendment to the United States Constitution ensures government employees like Kuether the right to associate for purpose of engaging in constitutionally protected activities, including speech, assembly, exercise of religion, and the petition for redress of grievances. As set forth above, plaintiff engaged in conduct that was constitutionally protected, suffered a deprivation of liberty likely to deter free speech, and a causal connection exists between her protected conduct and or political non-affiliation with the board and the adverse actions imposed by the board. In violation of Kuether's First Amendment rights and 42, 1983, defendants MPS Board, Posley, Furman, Cotton, and Holliday threatened to discharge, subjected Kuether to discriminatory terms and conditions, and constructively discharged Kuether because of Kuether's one, political affiliation with MTEA President Mizziaco, and the employees who wrote the petitions that Mizziaco presented to the board as a collective, which, objecting to the elected board's decision to promote Holliday to chief academic officer, and two, political non-affiliation with the current board. Defendant Posley acted under the color of state law when he arbitrarily assigned plaintiff to Washington High School for a punitive assignment in violation of the First Amendment of the United States Constitution. Through their acts above, defendants Posley and Holliday knowingly, willfully, or at least recklessly caused violation of Kuether's rights under the First Amendment and 42, 1983. Posley and Furman were personally involved in this discriminatory and retaliatory conduct that Terry and Holliday levied at Kuether, designing the special assignment at Washington High School and dismissing Kuether's complaints in favor of protecting Holliday. Defendants were aware of plaintiff's political affiliation and non-affiliation and took adverse employment actions based on it. Defendants and each of them possessed and exercised the authority to make final policy decisions on behalf of MPS and the board. Defendants and each of them treated plaintiff in accordance with an official custom, policy, or practice that was designed to punish and silence Kuether for her political affiliation and protected speech that criticized the current elected board administrations and their hiring practices. Plaintiffs suffered injuries as a result of an official custom, policy, or practice of MPS, the board, and Posley. Count 2, unlawful infringement on speech. Violation of 42 U.S.C. 1983 First Amendment. Plaintiff realleges and incorporates by referencing all previous allegations of fact. As set forth above, defendant and the board maintain an unlawful official policy, practice, or custom of intentionally restricting plaintiff's access to designated public forums and curtailing her speech within the same public forums. And said policy was the moving force behind defendant's violation of plaintiff's constitutional rights. Defendants Peter, Herndon, O'Halloran, Gokul Gandhi, Carr, Herndon's in there again twice, in accordance with the board's official unlawful policy, intentionally and or recklessly participated in the violation of plaintiff's constitutional rights. Defendant's infringement upon plaintiff's constitutionally protected speech and anticipated speech was motivated by the content, viewpoint, and message of the same, in violation of the First Amendment. The majority singled out and punished plaintiff based on speech it found offensive, and such treatment is likely to deter others from exercising public speech, especially unpopular speech. Count 3, Loudermill violation. Violation of 42, 1983 Due Process Clause of the Fifth Amendment. Plaintiff incorporates by reference all preceding allegations of fact. Defendants constructively discharged from her public employment based in part on the charges from Saffold. Posley made the decision to constructively discharge Kuether in consultation with Furman and others. Posley, Furman, and Cotton, acting under the color of law, conspired to deprive Kuether of her constitutional rights. To wit, Posley, Furman, and Cotton failed to give Kuether on 1, oral or written notice of the charges, 2, an explanation of MPS's evidence, and 3, an opportunity to tell her side of the story. Posley refused to act on Kuether's termination grievance. As a direct result of the defendant's action, Kuether suffered damages. Count 4, sex-based discrimination, disparate treatment, in violation of Title VII of the Civil Rights Act of 1964. Chapter 42, 2000E 2A. Plaintiff incorporates by reference all preceding allegations of fact. Plaintiff is a member of protected classes, white and white female. Similarly situated employees who were not white and female were treated more favorably than plaintiff by MPS. Plaintiff's race and sex was a substantial moving factor in MPS's decision to modify plaintiff's employment terms and to constructively terminate her. By evaluating and constructively terminating plaintiff's employment based on prohibited stereotypes about the proper role and behavior of white persons and or white females or employees in general and as a whole, MPS violated Title VII. MPS plaintiffs violated plaintiff's right to be free from discrimination in the terms and conditions of employment on the basis of her race as guaranteed by Title VII of the Civil Rights Act of 1964. It failed to comply with its statutory duty to make all reasonable and necessary steps to eliminate race and sex discrimination from the workplace and to prevent it from occurring in the future, causing Kuether to suffer even greater harm. As a direct and proximate result of MPS's discriminatory conduct as described herein, plaintiff has sustained and will continue to sustain economic and emotional injuries and damages, including to, but not limited to, loss, past and future income and benefits, and compensation for emotional pain and suffering, harm to reputation and mental anguish to an extent and in an amount to be proven at trial. Count 5, retaliation in violation of Title VII. Plaintiff realleges and incorporates by reference all previous allegations. As set forth above, Kuether opposed discrimination in the workplace and assisted coworkers in assisting discrimination in the workplace. Accordingly, plaintiff engaged in activities protected by Title VII's anti-retaliation provision 42 2000E3. In violation of Chapter 42, defendants subjected plaintiff to discriminatory terms and conditions of employment and constructively discharged her because she engaged in activities protected by Title VII. As a direct and proximate result of MPS's retaliation against Kuether, Kuether has suffered and will continue to suffer damages, including loss of wages, reputational and career losses, pain and suffering, and emotional distress. Count 6, discrimination in violation of the Equal Protection Clause of the 14th Amendment, Chapter 42, 1983. As set forth herein, defendant Posley, Furman, and Holliday, acting under color of state law, discriminated against plaintiff because of her race and sex, without a rational basis for doing so, in violation of the rights secured to him by the Equal Protection Clause of the 14th Amendment to the Constitution of the United States. Count 7, violation of the Wisconsin Public Records Law, Statute 19.31. Plaintiff incorporates by reference all preceding allegations of fact. Kuether made valid records requests of the defendants, the board, Mann, Posley, Peterson, Herndon, O'Halloran, Gokul-Gandhi, Carr. Defendants either failed to respond or unreasonably delayed the production of public records without giving a reason. Defendants either failed to respond or reasonably delayed the production of records because of Kuether's public activism. Defendants' actions in failing to produce or delaying production of records requested by Kuether, including her personnel file, have caused and will continue to cause injury to Kuether. Its actions also continue to deprive the public of its rights under the public records law. So now we get into the request for relief. There is a jury trial demanded, and this was submitted on the first day of April 1st, 2024. Actually, the day that it was due, and fittingly, it was April Fool's Day. Thank you for listening. We love to hear your comments, so please let us know what your thoughts are.